Glad to have a group of people here today talking about a subject that has been ever changing. This is probably going to be one of the more interesting CLEs of late because of the fact that the law has changed so much, procedure has changed quite extensively. And we've got three wonderful and very intelligent presenters today, Kelsey Allen, Hannah Brown, and Maria Miller, organized alphabetically, which, by the way, I've experienced that my whole life. Kelsey Allen works at Davis Immigration Lawyers and represents individuals in removal defense proceedings, as well as asylum, naturalization, family-based, and humanitarian cases. Hannah Brown is a solo attorney at HB Law and Advocacy. Her practice is focused on representing detained individuals in immigrants in bond and removal proceedings and federal litigation. She also works with the Los Angeles Innocence Project on helping to release people wrongfully convicted. And Maria Miller is a private attorney who practices at Martin Law in Bloomington, Minnesota. Ms. Miller's main areas of practice include removal defense, citizenship, asylum, and family-based immigration applications. And before we get going, I'd like to just put a plug in for why there's great value of the MSBA, especially with immigration and the significant changes that we've been seeing. The MSBA, we're trying to work to create connections and relationships that allow us to communicate and to get answers from stuff that that we don't know. And this bond process, I can say as a practitioner, is a real headache. And so I'm going to turn it over and hear about what we can do in light of all the changes. Thank you.
Thank you, Thomas. Hannah, do you want to go to the next slide? All right, so I'm going to start us off with just an overview of what to do when someone is detained. So the first thing you're going to get is a phone call, probably from a family member. It's usually not from the person themselves. During that phone call, you would want to try and collect as much information as you can. There's certain very key pieces of information that you'll need. So like the person's A number, their date of birth, and where they were born or where their nationality is. So sometimes people may be born one place, but their nationality is somewhere else. So you'd want to try and collect all that information because you'll need that information to be able to find them within the immigration system. To find someone within the immigration system, you'll want to first go to the online detainee locator system. There is a wonderful picture on the slide of what that system looks like. You can just do a quick Google search of ICE detainee locator and it will come up. You will go to that page. You'll type in that A number that you received from the family in the country of origin, and then you'll search by A number. Usually somewhere will come up, although there are definitely occasions where someone may not come up in the system yet. So there would be a couple of reasons why, or the number one reason why they wouldn't be there at all is just that they haven't been entered into the system. So if you're getting a call within an hour or 2 hours of someone's detention, they may not be into the system yet. It may just take some time. You'll need to keep checking. Sometimes it will also say that the person, that they're in the system, but you need to call the ICE facility to learn their location. So in that circumstance, you would have to call immigration themselves and ask them where they are. In Minnesota, there are some main places that they detain. The main places being Sherburne County Jail, Candiota County Jail, Freeborn County Jail, and Carver. The other presenters may be able to speak to this, but I haven't seen anyone detained at Carver in a while. I know this was an old place that was held, that people were held at, but I'm not sure how regularly it's being used now. Once you know where the person is, then the next step would be to try and get in contact with the person themselves. There's several different ways that you can contact the jails depending on where they are. So first of all, for Sherburne, the best place, there's two different ways that you can contact them. One is an email address that we can hand out to attendees. That's a great way to get documents signed. They are willing to accept documents through Sherburne. Through that email, they'll have your client sign it and send it back. If it's something quick, it does have to be legal related to their case. It can't just be anything, but they will help get documents signed. Sherburne also uses the NCIC system, so that's an online visitation system that you can sign up for, and then you can register calls with your clients, video calls with your clients. It's pretty straightforward. You do have to pay for it, but it does make things a little bit easier because you don't have to go through jail staff. Ojai County is probably the worst or most burdensome place for someone to be held. They don't cooperate as much as some of the other facilities. There is no way to get documents signed through email that I'm aware of. You just have to go the old-fashioned way and mail it to the person. I think if there's an emergency, you can call and maybe have something faxed, but they're not very helpful in that regard. In terms of calls themselves, it's sort of similar. There are emails that you can send to the facilitators, and they will pass a message to your client, usually the message being, can you give me a call? And then the client can call themselves from within the facility. And then Freeborn County Jail is somewhat similar to Freeborn. They do have an email address that you can use to get documents signed. You can call and set up an appointment with your client over the phone. So they'll do like a scheduled call. So you can call and say, hey, can I speak to so-and-so at this time? They'll let you know if that's available or not. Find a different time or whatever, but they are very helpful in facilitating the calls and getting documents signed to the client, documents signed for clients as well. ICE does have, that's kind of the local information. ICE does have a pretty good website of all the detention facilities and their policies for getting in contact with clients. So we can share that website after the CLE, but it's a pretty comprehensive list of all the facilities, and you can click on like visitation rules for each facility. And then again, they all kind of use different methods. Some use these different online resources where you can make calls or visitation, some don't. So then it's just figuring out if the client is somewhere else besides locally, how to get in contact with them at that facility. Next slide, unless anyone else has anything to add.
No, I guess one thing I would just add is I always, when I talk to the client, I know you mentioned it in your slide, Maria, about like the sensitive line. I always tell clients, because usually they might be in contact with their family and friends too. I just remind them, even though the phone will say it, like there's like an audio message that plays, but like some of the lines are recorded. So just remember that when you're talking to people, because people often forget.
Yes, that is a great point, that the calls are not confidential unless you specifically reserve a time for a confidential call with the detention facility. I will note, I do have a good fax number for Ojai County Jail that will facilitate getting documents signed for clients, so I can share that around as well. But they've been most cooperative via fax. And there was something else I was going to add. Oh, yes, I agree. I haven't had anyone detained at Carver County Jail for a while. I believe they still have an agreement that they can house immigration detainees, but I've not seen that in a long time. The only other point I would raise on this slide is that ICE won't share any information with you about your client unless they have a G28 on file. So this might come up for folks who are representing people, maybe before USCIS, who have been non-detained, and then they get picked up by ICE. Just because you have a G28 on file with CIS, or even an E28 on file with EOIR, if they were previously in proceedings, ICE is not going to tell you anything or share any information with you as their counsel until you send a separate G28 to ICE. And you can file that online. They have an e-file system, or you can fax it over to the field office where that has jurisdiction over the detainee.
And you don't have to have the detainee sign the G28 to fax it over. At least I've never had that issue. They will just let you sign for the client. We can also share that fax. I'm writing all this down so that we can send all this information out.
Yes, you can just write detained in the box for the client signature.
Okay, the next thing we're going to discuss is bond eligibility. This is probably the hottest topic right now in terms of who is and who is not eligible. It is changing every day. It's been a whirlwind of figuring out what judges are going to do, trial by error. I think we're pretty solidly in a space, at least right now, that bond is across the board being denied by judges if the person enters without inspection. After the recent decision in matter of Yajur Hurtado, there's no bonds for EWIs anymore. So judges have no jurisdiction anymore to grant any kind of bond after that decision. Before, it was sort of up in the air. It was a policy. No one really knew what was going on. But now it's pretty solidly there's a decision, pretty solidly a decision from the Board of Immigration Appeals. I would note that the Northwest Immigrant Rights Project has filed a class action on this issue already. It was filed several months ago because this was an issue that was happening in Tacoma, Washington as of several months ago, and so they had already filed. I don't know the exact status right now. I checked their website and it does look like oral arguments occurred on August 25th, but I'm not sure where that lands in practicality for all of us. Hannah, do you know?
Yeah, I think we're just waiting. Class actions move so slowly, and with the inability to get a nationwide injunction anymore, thank you to SCOTUS for that. We're all just stuck waiting for, you know, a typical class case, which can be years before a class is certified.
That's what I thought. So in that case, a lot of attorneys are filing individual habeas actions, which we'll talk more about later in the CLE, but that would be the only way at this point that I'm aware of, outside of just immigration agreeing, which is probably a non-starter, to release your client if they are iwi. And so to be clear, this is anyone that's iwi at all. It doesn't matter how long they've been in the United States. It is a massive policy switch since the beginning of time. It's a huge deal for immigration, unfortunately. Did you want to say something, Hannah?
No, just agreeing. It's a huge shift. I mean, this has been the law, and I think the plain reading of the statute and the intent of Congress and the regs for decades. And so this is really surprising, and it means a lot of people who have been, you know, at least would have been bond eligible and would have had a good case for bond, are, you know, if they get picked up, are going to be sitting in detention, you know, and might not have strong relief. And, you know, that's a whole separate topic, but it really, really limits bond for anyone who's not here or here without papers.
Yes, and so the only people that really are getting bonds right now are people that are visa entrants. So people that entered with a visitor visa or student visa or employment-related visa, some other kind of visa that enter the United States legally and through a port of entry, and then are picked up on something else, whether it be criminal or just picked up by ICE and by accident in a raid. Those are the only people that are being granted bonds right now. You can still file bonds. It's not as though the judges won't accept them, but at the hearing, they will find the person ineligible for bond based on the Board of Immigration Appeals decision. They are still granting them for visa entrants. I did have one last week without issue. They DHS agreed to the bond and they were released. There has been some issues with immigration also filing what are called stays. We'll talk more about that later, but I haven't seen that happen with visa entrants either. They are actually honoring those bonds and allowing those people to bond out. Other people that have historically not been eligible for bonds, this isn't a new thing. It's just always been this way. Arriving aliens are not eligible for bond. People with prior deportation orders are not eligible for bond. There are different ways that one's criminal history can make you ineligible for bond. For example, if you're convicted of crimes involving moral turpitude, depending on different factors that might make you ineligible for bond. And then there also was the Lake and Riley Act passed beginning of this year, making people ineligible for bonds if they have certain types of convictions or arrests. These are tricky because they involve not only convictions for the crimes, but also arrests for the crimes, even if those arrests did not result in a charge or a conviction, or if the charges were dismissed. The way the law is written, those people would still be ineligible for bonds. Anything else to add on those slides?
No, we can go on. Oh, I will add something actually. I know Maria mentioned that this has gone up on habeas sort of in across the country, that people are challenging this, you know, the Ujiri Hurtado case and the policy. And pretty much across the board, federal judges are dismissing this, not dismissing the habeases, but dismissing this stance and this decision by the board. There are a couple cases that have even come out in the 2 weeks since this Ujiri Hurtado case, where federal district courts have stated that the board was clearly wrong on this. You know, those are only individual cases, so they help those people who file the habeases, but this is, I think federal judges agree that this is not a reasonable reading of the law by the Board of Immigration Appeals.
Great. Yeah, so when you're requesting a bond hearing, I mean, in my experience, any case in recent years, it's going to be electronic on ECAS. So you would go on your portal, and then it just kind of depends like what the situation of the case is. So you can request a bond hearing even if the NTA, the notice to appear, has not been filed yet, which actually comes up quite often because a lot of courts are kind of behind on entering NTAs. So if you know somebody's detained, they're in immigration detention, but when you look up their A number on the EOIR, case lookup portal, automated information, if it says there's no case, that doesn't mean you can't ask for a bond. So what you would do is you would go in your portal, and then under the appearances tab, that like top little photo that we included, you would say you want to file an E28 with a bond request. And then you just enter your information, upload the bond request. And so that's how you can ask for one without the NTA being filed. In the past, you could also mail a letter to the court with a request for the bond hearing. You typically say where they're being detained to show that that court has jurisdiction over this bond hearing. You would say that, there obviously they've not been granted any sort of bond, which I think like right now, we're not really seeing any bonds typically being granted by ICE. In the past, maybe ICE did grant the person a bond, but it's too high. They're not able to pay it. And so they're still in detention because the bond is just too high. And so you might ask for a bond hearing so that the judge can lower it or hopefully lower it. So anyways, that's how you would do it right now. And then if the NTA has been filed, then you can, just go on your case portal, and like I kind of included photos here, so you can enter your appearance for them. And then there's a little request bond area. When you pull that up, the photo on the right comes up, and then you choose the court, and then you choose the files that you want to include. So that's kind of how it works now, since mostly all cases are ECAS. One thing I'll just bring up that I saw, maybe other people have seen this recently too, just because like somebody might have a case that's already pending. I just had this. I had a lady who she was picked up under Trump 1.0 for being a passenger in a car, and that car was like apparently speeding. And so she got put in proceedings, and she was eligible for a U visa. So I filed out for her a couple of years ago. And then the case had been administratively closed ever since with Fort Snelling. And then she got arrested by ICE at her job. She has no criminal history. It was because, my opinion is because she, has ties to a boyfriend that was recently deported by ICE. And I don't know, I don't know why, but that's all I can tell about why she was arrested, because there was nothing else. And ICE found her exactly where she said she would be on her paperwork, like at the job she works at. So anyway, she was arrested, and her case was, or has been, with Fort Snelling. She was in South Dakota, I think, at her job when she was arrested. So South Dakota would be with Fort Snelling also typically. There wasn't enough space at the jails in this area. So she actually ended up getting sent to Iowa. And so her court was actually with Omaha. So then when I was requesting the bond, that's where you say select base city. It's not necessarily the city that the case started with, because there it was Omaha that ended up doing the case. And so you just want to pay attention to that. With there being a lack of space for ICE detainees, people are being transferred more often. And then you just have to make sure you reflect that on any of your filings, that you have the correct court.
And if you did do that, if you made the mistake, then what would happen is the bond would probably get scheduled, because the court probably wouldn't notice. And then right before the hearing, they would cancel it and say you filed it in the wrong place, and then you'd have to redo it, and then the client will have to wait. So it's not ideal, but it's not the end of the world, I
Yeah, it's not like the bond is denied. It's just you did it in the wrong area, the wrong place, and then you have to do the correct court.
And that same thing happens if they move them. So like if like Kelsey's client was in Minnesota, but then they lost bed space or whatever, and they moved the person to Iowa, or somewhere else, Colorado, then your hearings will also, the court will not hear it in Minnesota anymore. They'll change venue to wherever they are now detained.
And it's also, even though they file, maybe you guys know the technical name, it's like I-8 something, the address change of the detainee. Really, it's on us to make sure we're up to date with where our client is, because oftentimes somebody will be moved and like I've never had an ICE officer call me up to tell me somebody's being moved. Like we have to stay on top of it. Even honestly, even if you file a request and you know the person is at that jail, I continue checking just to make sure they stay at that jail through the hearing date.
Yeah, if you e-file an E20 or a G28, I'm sorry, on the ICE's e-file system, there's a way to get notifications for when your clients are transferred between facilities. Those notifications are not always accurate or up to date or come in a speedy fashion. So definitely don't rely on those and do check on where your clients are. I wonder, Maria and Kelsey, what you've seen lately. You know, before this Ujiri Hurtado case, I would comfortably say it would take at least 2 weeks for the first bond hearing after someone's apprehended, probably closer to 3 weeks. You know, I think with fewer and fewer people being bond eligible, it might not take as long these days, but I think you could reasonably prepare your client to be detained for a couple weeks before their first hearing. What do you guys think about that?
Yeah, the lady that I was giving the example of, she was detained for 3 weeks. Yeah, single mother, no crimes, already had a case pending. And, you know, I already had her file with tons of evidence to use for a bond. And so I asked for a bond really quickly. But yeah, Maria, I'd like to know what you've been seeing. But that is something I think under this administration with bonds that's different in the past. In the past, I actually might not file my bond.
I think Kelsey froze. I'll let her know. She's got some spotty internet. I think what she was going to say was that
Like,
you're back, Kelsey, you cut out there.
oh, I was just saying that, you know, you can kind of count on it taking a while.
Yeah.
Yeah, I haven't seen anything any faster. I think sometimes it takes the family time to kind of figure out what's even happening, and then the court schedules it, and that's usually 3 to 4 weeks out as their initial master, and then the court usually just piggybacks off of that. I mean, I think you could probably ask for it sooner, but I don't know that the court would find a slot because there aren't, I don't think, correct me if I'm wrong, I feel like this might change, but the court has always kind of sometimes has gone back and forth about piggybacking off masters and having bonds at the same time. And then there was a period of time where they were just doing bonds. Like the only thing that happened at the hearing was bonds. And so in those contexts, it might have been easier to get a hearing sooner because it was on a different day. But now I think the court is like, why would we do that? Why would we not just piggyback off the master? So usually, barring some unforeseen event, I think you can probably just assume that your bond will be the same day as whenever their initial master is. And then courts usually give 2 weeks in between, although it seems more regularly that they've been giving 1 week in between masters. So like if they hire you the day of their master or whatever, then you can probably safely assume that the next one will either be a week or 2 weeks from that specific date. So they have specific judges on specific days, Tuesdays, Thursdays, whatever, and then they track with that judge usually.
Yeah, that's what I've seen. I recently filed a couple different motions to advance for a client who had his first bond hearing set out. I think it was 3 or 4 weeks, and it was a medical situation. And despite doctor's notes and medical records in the motions to advance, the court just said, sorry, we're all full on time slots. So, you know, someone even who is bond eligible who entered on a visa will probably be sitting in detention for a while before their chance to be heard.
Yeah, I would agree. I think there's just not in the court size space to move people forward because there are other people in masters. It's not like the hearings just aren't happening. There's the full calendars either way.
Yes, and our local court lost Judge Sarah Mazie, immigration judge Sarah Mazie, who had been, I think, the primary detained judge. She's with the Board of Immigration Appeals, at least for the time being. So we're short a judge here locally.
I might interrupt and ask a quick question. For everybody listening, give us perspective on, do you guys know about how many people they're detaining that are in the detained system right now, and how many judges are working on it?
In Minnesota or like nationwide?
No, just in Minnesota. Like, what are we seeing locally? And
I don't.
Yeah, I don't have numbers. I think anecdotally, it seems like all the I think the judges who I've seen handling detained cases are immigration judge Miller, immigration judge Sardelli, immigration judge Zaski here and there, and a lot in front of immigration judge Ivany. So like 3.5 judges handling all the detained cases. We also have immigration judge Carr here, but I don't see her before detained cases very often, only if she's filling in for someone.
I would agree with that. I don't know how many people are in detention in Minnesota, but I agree. I don't know that I've ever seen
Those numbers are online. I think
Sardelli, but-
ICE sort of proudly publishes those on its website, apprehensions and detentions by field office. So I think they have like a big chart with graphs and all that can be discovered and played with.
Yeah, and I think just from Trump 1.0 to now, what I've experienced is we have way more judges now, yet the wait is much longer. So, I mean, to me, that just tells me there's way more people in detention right now.
Yeah.
Okay, Hannah, do you want to start with this or?
Sure.
Me? It doesn't matter.
Yeah, just to jump in, Kels. So if you're lucky enough to get a bond hearing, if you have a client who's bond eligible, you want to be preparing a packet, right? I sort of take it as like one giant filing with all of the supporting evidence. It is the non-citizen's burden to establish that they should be released into the community, and it's their burden to establish that they are neither a flight risk nor a danger to the community. That comes from board case matter of Patel, and then later on matter of Guerra, which I've got on the screen here. Matter of Guerra laid out these nine factors that you can see in the chunk of text here: fixed address, length of residence in the U.S., family ties, all this. I'm not going to go through all those factors, but newly there's been a case, literally, I think it was a couple weeks ago, that from the board that says, you sort of need a notarized affidavit, maybe like an I-864 sort of type thing, from a U.S. citizen or LPR, I think, to show that you are not a flight risk, that you need a U.S. citizen sponsor. Even if you've lived here for 10, 15, 20 years, even if you have children and a business, you need some U.S. citizen to vouch for you. That's a new thing. So, as you're thinking about flight risk, I think, this comes up in a lot of other case types. You can think about your lease agreement. The judges here really love to see lease agreements or mortgage statements. That seems to be a really big deal for them. And then on the other side, you have to show that your client is not a danger to the community, which I think is, we'll talk about a little bit more. Kels, is there anything I'm missing here?
No, yeah, I just add that new case about the sponsor. It's like, I mean, as people probably know, we keep getting all these new published cases, and it doesn't say you have to have a sponsor. And it doesn't necessarily say that it like has to be notarized, but basically with bond being so challenging, if you want to do everything possible, it's almost like it is a requirement now. Even though it's not like a formal requirement. And then we just kind of listed in there different things to have the sponsor include in their statement based on, cases that this new case cited. But yeah, one thing I'll just say about bond overall is there's not really a ton of rules. It's really like you can be creative and the more you can add, the better, and just constantly trying to anticipate what DHS will say, which we'll talk about later. But even though this isn't a requirement to have a sponsor, you can anticipate they might bring this up given this new case, and being ahead of it is definitely like where you want to be with this administration.
Yes, and the sponsor, this case, which I'm not going to try to pronounce the name of, was not entirely surprising to me outside of our local jurisdiction. When I've represented people who were transferred to Colorado, Louisiana, I've had judges or immigration judges reference like, hey, don't you have a letter from a sponsor? Which is not something that our judges here locally had been asking for. So I'm not shocked to see this. It just seems like, someone at the board liked that an immigration judge sort of invented this new requirement, or, not requirement. And now the board has codified it as well. This is just a reference of some, examples of, Kelsey said, getting creative for documents and evidence you can file in support of showing your client is not a flight risk. I would just flag relief from removal. I feel like we keep saying like, this isn't how it used to be, but now, now this is the case. It didn't used to be that you had to file, proof of relief from removal or even like prima facie eligibility. You could just say, my client is probably going to seek fear-based relief, or they have a kid who can, sponsor them, whatever it may be. And judges sort of took that as, it's just one factor of many in this list from the Matter of Guerra case. And I think if possible now to either file an application for relief or show that your client is prima facie eligible for some sort of removal relief, I think that's going to help your client a lot more than not.
Yeah, I agree. That's been a big thing I've noticed with Ivani, that she'll still deny bonds. Like with Maisie, it was Loy Hannah's describing it. Like, oh yes, they may seek this, even though we're outside our 1-year bar. And she would make a comment about, they're going to seek this, but they're outside their bar. So I don't know how viable that relief is, but either way, I'm granting bond, blah, blah, blah. Ivani seems to be much more like, well, no, I don't see any viable relief options, bond denied. So it is definitely becoming a much bigger issue than it ever has been before.
Yes.
One thing
Go ahead.
Go ahead. Oh, I was just going to say that when I was waiting for one of my bond hearings, I was listening to somebody else, and they had Judge Miller. And yeah, we got to the relief of removal, and, DHS was saying, oh, they're not eligible for anything and this and that, and they've only been here 3 years and whatever. But the attorney kept saying like, well, we're gonna plan for voluntary departure, blah, blah, blah. And Judge Miller was kind of echoing what DHS was saying, which is like, well, just take it now. Just do this now. I can just grant voluntary departure right now with all of this. And I don't remember exactly what the attorney said, but he just kept bringing it back to, this is the bond hearing. He's entitled to a bond. He is eligible for voluntary departure, which we'll seek at a later hearing after he has the opportunity to bond out, which will allow him to get prepared for voluntary departure. And just explaining like why voluntary departure would be, I
think she cut out again. I think, yeah, explaining why voluntary departure is still, there you go, she's back.
Oh, just be prepared that the judge might pressure you into trying to take that relief then.
Yep. So the other sort of hurdle in bond is that it's your burden to show that your client is not a danger to the community. For people who do not have any criminal record, I've never seen a judge or DHS make this an issue. Even for people who have, Kelsey, I'd love to hear this.
We have it later, but I saw in Omaha somebody arguing. There was like a big raid at an employment place, and so a bunch of people were working with fake work authorization cards. And yeah, they're making the argument that because you're working with a fake social, that social could belong to somebody. And if that social does belong to somebody, by you working with that number, that could be preventing them from getting the public benefits that they could possibly want. The judge was having none of it. But I was like, wow, I've never heard this argument before. I've never heard that like working illegally is dangerous. But it's out there because I've heard it.
Maisie has sort of made that a similar sort of argument, like when someone is charged with document fraud or using a document. I don't think she's not denied bond for it, but I think she did. I remember a hearing where someone said like, well, that's not a danger, and she did not like that. So there, yeah, it definitely exists, but more traditionally, it's going to be actual criminal history.
Yeah, and it's not necessarily convictions. I think everyone here, or I hope everyone here knows the immigration court is not like state or federal court where there are rules of evidence. The judges love to take what is in the criminal complaints or in the police reports as fact. And if there might not even be a criminal complaint, there might have just been an arrest. So there might only be a police report. And the immigration judges generally want to see those police reports, even if charges weren't filed. And you have to be really careful about what you're providing to the court, because it is your burden to establish that your client is not a danger. And withholding, the police report or the complaint from the court, that might just leave the immigration judge with more questions and might allow DHS to either file the police report or complaint, although they very rarely file anything in bond cases. Or it might just allow DHS to sort of wildly speculate on the record. I think we've all seen that from OPLA, where they sort of like spiral into these hypotheticals of like, well, if this person was arrested for drinking and driving once, maybe they did it 15 times. How are we to know? So sometimes you have to use your judgment as counsel, but sometimes providing a document, a complaint or a police report that might not be 100% favorable can still help stop DHS from spiraling out of control onto the record in hypothetical situations. Most important for bond is going to be evidence of rehabilitation, I think, for any prior criminal history, whether that's, if there was a DUI or a DWI, that those are really hard to get bonds, especially if you have two or more. There's just some really challenging case law there, but showing that your client went to Alcoholics Anonymous or NA, something like that, a positive chemical assessment, things like that can be really helpful to show the judges really, I think their perspective is that they don't want to send someone out onto the street who might commit another crime or who might harm someone.
Yeah, I agree. That's what I feel like my perception is in their head, they're thinking, how do I know this person isn't going to do X, Y, Z again? And if you can show them something that kind of sets your case apart, like, some creative ideas, again, like even if it's, look I have a $50 bus pass my friend bought me, or here's these credits on my Uber account, or like letters from people with their driver's license saying they're going to drive, that even though it might not seem like that's a big deal, it at least is something. And I think it kind of depends. It shouldn't be this way, but kind of depends on all the other cases they're seeing that day. And if nobody's having good evidence, and then you come in with these like, oh, cool ideas that they're not seeing, it like makes your case look so much stronger.
I would too, as much as you can, try and get ahead of it. So if you have a client call you and say, hey, I got arrested for a DWI, immediately tell them to go do AA, go do these things, so that if they do get picked up, you have the evidence. You can get evals in jail sometimes, but it's tricky. It takes a while. It depending on when they call you, you might not have any time. You might not be able to get a hold of anyone. So it can happen, but it's kind of a hassle. So to the best of your ability of trying to get ahead of stuff. Like I will always have clients, like if they get an assessment and the assessment says they don't need anything, I still tell them like, it doesn't matter, go do all these other things, because if the worst case you get detained, at least we have evidence to show that you're trying to rehabilitate yourself.
Yeah. The only other thing I'd stop on this slide is to say you definitely don't have to file a legal brief or written arguments for a bond hearing. And I think the judges don't see it often and don't really expect it. But if you do have a case, maybe with a particularly sympathetic client or particularly complicated issues, I think it is worth it to file written arguments, particularly if you anticipate this might go up on appeal. Helping to highlight certain evidence in your packet for the judge can be really helpful. I've done that before and had judges, I think, grateful for that, like sort of hand-holding through the process, because they'll get, sometimes 10 pages, sometimes 20, sometimes 100 pages of evidence in support of someone's bond. And they're doing these cases so rapid fire. They usually, or often I should say, have not actually reviewed the evidence ahead of the hearing. So it can be really helpful if you have just like a succinct, here's the facts, here's how they apply, here's how they apply to the matter of GARA factors. Here's the evidence we have. I think that can be really helpful in stickier or more complicated cases.
And the only other thing I'll add is there is no testimony, as this says. I've never ever had a judge take testimony. And I've actually recently had a bond in front of Miller, and Miller didn't even let the family members into the hearing. He tried to claim it was private and that no one could observe the hearing because there were like security risks involved with that, because they weren't sure if someone was recording it, which all just seemed very strange, because then he in the same breath said, but a witness can do that. So I'm not sure what the difference is. It was very strange. I fought back, and he ended up letting the wife stay on the call, but it was just, it took me by surprise, because I've never had a judge tell me that someone can't listen to a bond hearing. So take that for
I
what it's
think
worth.
that's a good point, to just expect that something might come up that you've never seen, because I've also never seen testimony taken until this summer when I had a bond hearing, and I was looked at like I was crazy because I was confused that people were going to take testimony of my client who had no criminal history, also different client. And the bond hearing took an hour and a half because of all of the testimony from DHS and Judge Ivany. And this was when CLE was like just released, and ultimately after an hour and a half of testimony, Judge Ivany just said she didn't have jurisdiction. So that's like not common at all. But I feel like whatever you think is normal, sometimes the judge will say, no, of course we do it like this. And then you just kind of have to go with the flow.
Yes, expect the unexpected in detained proceedings, bond proceedings, I think immigration law in general right now. And to Maria's point, I've had a much harder time getting hearings closed by the judges when I don't want observers in, or I don't want, anyone to be listening in on the hearing for, safety reasons for my client. The judges really have pushed back on me and my many requests for closed hearings, which, is a different topic for a different day.
I've got a quick question before you keep going. You guys, you're arriving at your bond hearing, you're close to it, and you don't have all your evidence, or you think that there's something important that's missing. What do you do? How do you handle that?
You can ask for a continuance, so you can let the judge know that there's something missing and you want a continuance. A lot of times judges will just withdraw the bond request and say, okay, that's fine. When you're ready to go, make sure you file, or just file when you're ready and ask for a new hearing. Again, usually it will be the week or two after, depending on whenever they reschedule the master. I think the one word of caution that you want to be careful about is to make sure that your client is prepped for that to occur, especially if you don't represent them in their master calendar hearing, because the court is still going to go forward on the master calendar. So if you withdraw the bond and they sit there and say, well, I don't want to do this anymore, and then they get deported, or they don't have any relief options and the court takes pleadings and they disastrously answer those questions, you could be looking at a very different situation. So it's perfectly fine to ask for more time, but you just need to be prepared for the other part of the case to keep going, regardless of how much time you need in the bond.
Also, one thing I'll add that we didn't really mention, but so I think like technically your criminal records are supposed to be certified. I've never once done that in Minnesota. It's always been fine. I just go on MinSys and download whatever is on there if you have stuff. But in my experience, like really it's just the criminal records that I've seen a judge tell people like, oh, if you don't have that, I'm not even listening to this. All of the other evidence can definitely be really like important and helpful, but like when I get a call from somebody that's detained, I think maybe Maria or Hannah already mentioned this, but like the first thing I'm saying is go work on getting the police report, go work on getting the court records if I can't access them, if they're in a different state or something, because that's like, in my mind, the one like true requirement for the hearing to go forward.
Yeah, I agree with all of that. I will also say, I don't think we mentioned, there's technically not a filing deadline for filing your evidence in support of bond. So, you know, for electronic cases, as with any other removal case, everything has to be electronically filed. I have been admonished for filing things less than 24 hours before the hearing. The different judges have different requirements. Like I said, some of them don't really even look at the evidence until the morning or the day of the hearing. So I just sort of, you know, personally try to make sure that everything's on file 24 hours before the hearing, although there is technically no filing deadline. There's no standing scheduling order from any of the judges that give a filing deadline. So, and I've also seen DHS file stuff during the bond hearing or in the hearing or the morning of the hearing without issue or pushback by the immigration judges. So know that you can still file stuff. And it is sort of a more, I think the custody hearings are a bit more of a casual format. And, you know, maybe a little bit more conversational as the judge is trying to understand the person's background and history. And so you can say like, well, you know, I have 10 years of taxes, but I didn't know if you would actually want to see those. They're ready to go. I can upload them now. And you know, judges might give you a couple minutes to upload them. So, you know, be ready to be creative. Or, you know, if you're in the hearing and you say, well, you know, we have medical records, or the family has medical records, they just haven't landed in my office yet, the judge might then give you a week continuance to upload those.
I think a lot of judges don't want to continue stuff. They want stuff to keep going. And so if it is something small and you upload it, they may like not be happy about it, but a lot of times they'll go anyways because they don't want to take another week either. There was another question on the chat. Have you seen social media activity or affiliations to certain groups or movements be used as evidence of danger in a bond?
I have, but for my experience with it, I've had like multiple bond cases where these people were totally targeted by ICE, despite no criminal history, but because of their extended relationships with other people that I feel like was on ICE's like bad list. So I just expect if something's on Facebook and it's posted publicly, like they have the screenshot and they're ready to show it and they're ready to ask you. So in the case that took an hour and a half, you know, there were screenshots. Well, why did you post this about this person? And it wasn't really any political opinion type issues. It was more about how they were related to somebody else. And that's why ICE thought they were so dangerous. So yeah, I assume that, you know, they've already looked at their social media. I think it's like, in my experience, rare that they use it for the average bond case, but when there is like a targeted arrest, I've definitely seen it be used.
Yeah, I think that's exactly right. That's what I've seen too. I don't think every single person who's detained by ICE has I think just like for sheer lack of time, I don't think OPLA has the time to be going through everyone's social media. But if there's someone that they think, you know, they might be able to charge with a national security or foreign policy charge or issue, that social media is used to show dangerousness. And that can be challenged on habeas because that's a First Amendment issue.
We do have 10 minutes left if we want to keep going.
Yeah, here's just some wild arguments that some are wild, some are not. But basically, you can prepare for your hearing by expecting, I don't know, like just think about anything that DHS could possibly say and just be ready for it. So here are things that I've heard repeatedly. I don't know if anybody else has any main ones, but you might think like having a fake ID isn't dangerous, but as Maria mentioned, it has come up on danger before. So just being ready for it.
All right. Is this my section? Sorry, I'm not. Okay, thank you both. So when bond is granted, on the occasion that it happens now, there are a couple steps to getting your client out. It's not, you know, a quick process. It doesn't happen within a couple hours. I usually tell my clients when bond is granted, have the money ready. I tell people like have at least $10,000 ready because we don't know. Even if we go and ask for a bond of $1,500, which is the minimum that the judges can grant, they might go 10, 15, 20. I think Kelsey has seen like an $80,000 bond granted before. So try to have the money ready to go. The sooner the better. It can only be paid online and can only be paid in full. I do not recommend connecting your clients with bail bondsmen. I think that that's putting people who are immigrants or connected with immigrants in a situation that could potentially harm them or put them in a really financially devastating situation. So I try to encourage my clients not to use bondsmen and to pay the bond in full. It will sit in some ICE bank account for years until proceedings are resolved one way or another, and then it will be returned to the payor, which is called the obligor. The only situation in which the bonds are not paid online, I believe, is people who have pending U visas. They can't pay through ICE bonds online. I think it might be the same for VAWA. And there's a local contact at Fort Snelling who's actually very helpful in facilitating those payments. But that takes a little bit of extra time. No matter where the person is detained in Minnesota, sorry, they'll be brought back to Fort Snelling to be processed out. This does usually take, in my experience, a couple days after the bond is paid. You know, it used to be the same day the bond is paid, then it was 24 hours later. Now it's gonna take a few days, unfortunately. I think that's just like the sheer number of people in detention now and the lack of ICE agents to do the paperwork. So they will be released from Fort Snelling. Removal proceedings will continue. I'll sort of try to breeze through this as quickly as possible because it could be its own whole hour-long plus talk. When bond is granted, ICE, DHS may appeal. They often reserve appeal. If within 24 hours of reserving appeal, they file a form called an EOIR 43, that invokes an automatic stay of the judge's decision to grant bond. So I've seen in cases where bond was granted and DHS reserved appeal, the family tried to pay the bond and wasn't even like, there was some notation in the online system that wouldn't even let the family pay the bond for those 24 hours. If that's filed within 24 hours, the person remains detained. You still brief like any other case before the board. You wait for a briefing schedule. I've had this happen. It goes pretty quickly. I think briefs are filed usually within a month to 5 weeks, and then you wait however long you wait for a decision from the board. If this sounds like an extreme measure, it's because it is. This historically had not been used except for in like very serious national security cases. This was a very rarely invoked. It's actually a regulation. It's not part of the statute by Congress. There's no case law that allows for this to happen. This is a regulation that was written by DHS in 2006 after 9/11 when it's a part of the Real ID Act. The only way to fight or challenge this, which, you know, it sort of puts you in this like very confusing situation where you had an immigration judge say, this person is not a flight risk, this person is not a danger to the community, and yet you can't pay the bond to get them out. So this can be challenged on habeas corpus petition at the federal district court. Here in Minnesota, the district court judges do not like when ICE invokes the automatic stay. They found it to be unconstitutional in violation of due process in several published decisions. And that's the same across the country. I think there are a couple of negative decisions in some states down south, but it generally, when this gets before federal judges, they look at all the facts, they look at the factors in evaluating a due process claim, and they find that this violates due process because a judge has made this decision, and ICE is effectively able to trample over the judge's decision by just filing this one form. They don't even have to show, a likelihood of success on the merits or anything like that. Practically, though, this results in people requesting to be deported because is it possible to file a habeas? Is it possible to fight their case? Is it possible to keep the energy up and possible that they'll get out after 2-3 months? Yeah, it is. And I would say there's a good shot if someone was granted bond, especially if you're in Minnesota and you file a strong habeas, that person can get out. But that's several months separated from their family. That's several months of not working. And on a practical basis, this means people are just asking for voluntary departure, or they're just asking for a removal order so that they can get out of jail. They're we call it detention. They're in county jail. Let's see, if bond is denied, the non-citizen has the same right as ICE does to appeal to the board. There's no stay of any decision from the judge for the non-citizen. It's an E-26, which is the same form that you'd file in any other removal case for an appeal. You can also, sorry, I'm speeding through this now, hoping to leave like 2 minutes for questions at the end. You can also file a habeas petition to challenge unlawful detention. Prolonged detention is not really a viable habeas here in Minnesota or in the 8th Circuit. Though you can try, I don't recommend it. It's not usually successful. Removal proceedings continue even if the bond decision is being appealed. You'll just sort of, the custody case and the removal case just sort of move on separate tracks. I think it's usually pretty rare that you get a bond appeal decision prior to a removal decision if the cases continue on, but it's worth the fight, particularly if it's an interesting issue or a complicated issue. You can't always request another bond hearing. If the judge denies bond, you have to show a material change in circumstances since the prior bond hearing. Judges rarely find a material change in circumstances, particularly because someone has been detained the entire time. The circumstances don't often change. Sometimes, if there was a criminal proceedings continued and there was an acquittal or a dismissal of charges, that can be a material change in circumstances, but otherwise there's very few. Is this me too?
Yeah, I think so.
Okay, I'll just run through this super, super quickly. We just recommend that you have your clients ready for detention. Unfortunately, it sounds a little bit doomsday, but I think Maria sort of touched on this earlier. You can't be prepared enough. I tell my clients have a hard copy and a digital copy of IDs, taxes, leases, all the stuff we talked about that would be used in support of bond. Have your criminal records ready to go so that you can request a bond hearing as quickly as possible. You don't have to get continuances. And you're just ready to hit the ground running as soon as someone's detained. If someone has children, have a power of attorney ready, have, custody orders in place. If you have a business, have a succession plan in place. You got to plan for at least a month in detention. And that's if you're lucky enough to get a bond hearing.
I agree with that. I think mentally it's really important for clients to prepare too. I think we can talk all day about documents, but the amount of calls I get for people that just don't want to do it anymore is very high. So I think it's really important to prepare people that you're going to be in jail for a couple of months on the long end, and there's nothing that's going to change that. And so you need to decide if you can do it or not.
Yeah. And the last thing here, I sort of touched on all of this already. Really the only way to challenge someone's detention other than through a bond hearing is a habeas corpus proceeding at the federal district court. Don't try it alone. If you are not a habeas practitioner, it's crazy and complicated and confusing. So reach out to someone who you know has been filing habeas petitions, or to the ACLU or one of the nonprofits who is doing it. I think it's a really viable strategy to get someone released, but it is not not a good approach for someone who's never been in federal court or who's never filed a habeas petition before, but there are plenty of groups who are willing to help and mentor you in doing so. I think that's all we got.
I see there's one question, just about like, are people filing bonds in EWE cases despite the new decision? And we had kind of talked about that, and you guys can touch on it more, but it's just, you kind of have to take some like ethical considerations into account, and just like really honest conversations with clients about like money and likelihood of success. And, you know, are you planning to file like a lawsuit after, because you're not going to be granted bond right now? I don't know if anybody else wants to add anything.
I think too, like, if they're going to file habeas, I think they probably could just move on to file habeas now with the decision. I don't think you even need to seek a bond anymore. So I don't really know why you would file them at all, I guess.
Yeah, I agree with that. I think the ethical consideration is number one of like, are you taking someone's money to do something that you would be in effect a frivolous filing at this point? You know, it's unfortunate, and that's why we have to mentally prepare our clients beforehand. Yeah.
And maybe the conversation is, well, we could fight your removal case, and during the pendency of that, hopefully something changes. And then if it does, we can file bond. But the other thing to consider is that you cannot, like Hannah mentioned, you can't go back and try again unless circumstances change, which I suppose a change in law may be changed circumstances. But I sort of got tricked into this by Ivani at one point, where she denied jurisdiction, but then also found my client a danger. And then when the laws did switch, she was like, well, I'm still finding him a danger, so I'm not giving you another bond hearing. And so I think like being careful of the record you create is important too. And I don't see any benefit right now at all on moving forward in a bond, because you're creating a bad record for yourself, I think.
Yep, I agree. All right, well, thanks everyone for joining. Anything else?
Wonderful. This has been a great presentation. Thank you, the three of you, for your expertise and guidance. And this is another step of the MSBA in helping to connect everyone with very, very smart people that have a lot of experience. So thank you, and we'll see you all in court.
Thanks, everyone.